Hello friends, myself Mohit and I am going to dictate you Steno legal matter. Please subscribe my channel and press the bell icon for more dictations. So be ready for the dictation. 5, 4, 3, 2, 1, start. The done of a power of attorney may, if he thinks fit, execute or do any instrument or thing in and with his own name and signature and his own seal, where sealing is required by the authority of the donor of the power, and every instrument and thing so executed and done shall be as effectual in law as if it had been executed or done by the donee of the power in the name and with the signature and seal of the donor thereof. Stop. This section applies to powers of attorney created by instruments executed either before or after this act comes into force. Stop. Learned counsel for petitioner submitted by citing it was held that wakalat, though a kind of power of attorney, is confined to pleader. Stop. Power of attorney agent cannot carry on business as attorney or solicitor. Stop. The principle involved is that act of pleader is something personal which could not be performed by GPA, general power of attorney, since knowledge in and application of law by a pleader is purely personal with degree of variance from it, was so held in para 14 to 16 as follows. 14. Section 2 of the Powers of Attorney Act cannot override the specific provision of a statute which requires that a particular act should be done by a party in person. Stop. When the code requires the appearance of an accused in a court, it is no compliance with it if a power of attorney holder appears for him. Stop. It is a different thing that a party can be permitted to appear through counsel. Stop. Chapter 10 of the Code empowers the magistrate to issue summons or warrant for the appearance of the accused. Stop. Section 205 of the Code empowers the magistrate to dispense with the personal attendance of accused and permit him to appear by his pleader if he sees reasons to do so. Section 273 of the Code speaks of the powers of the court to record evidence in the presence of the pleader of the accused in cases when personal attendance of the accused is dispensed with. Stop. But in no case can the appearance of the accused be made through a power of attorney holder. Stop. So, the contention of the appellant based on the instrument of power of attorney is of no avail in this case. Stop. In this context, reference can be made to a decision rendered by a full bench of the Madras High Court. A person who was the power of attorney holder of another claimed right of audience in the High Court on behalf of his principal. Stop. A single judge referred 3 questions to be considered by the full bench, of which the one which is relevant here was whether an agent with the power of attorney to appear and conduct judicial proceedings has the right of audience in delivered the judgment on behalf of the full bench. Stated the legal position thus: an agent with a power of attorney to appear and conduct judicial proceedings but who has not been so authorized by the High Court has no right of audience on behalf of principal either in the appellate or original side of the High Court. Stop.